Good afternoon, ladies and gentlemen. I'd like to begin by welcoming to Dartmouth the class of 2018 and by welcoming back to our returning students for another year. For those of you whom I haven't yet had the chance to meet, my name's Andrew Samwick. I'm a professor in the economics department and the director of the Nelson A. Rockefeller Center here at Dartmouth. The day-to-day mission of the Rockefeller Center is to educate, train, and inspire the next generation of public policy leaders. One way that we seek to do that is by hosting lectures on a broad range of topics in public policy by leading academics, policymakers, and practitioners. If you want to stay informed about our programs and events, please go to our website, rockefeller.dartmouth.edu, to sign up for news updates via email or your favorite social media services. It is a recent tradition at the Rockefeller Center to begin our academic year of programming with an event in honor of Constitution Day. The Constitution establishes the government, and the government is fundamental to the public policy outcomes that we study. The Constitution is the singular document that guarantees a representative form of democracy and has formed the basis of our freedoms for over 2 centuries. It has not been a static document. We often hear references to a living constitution or an evolving constitution. If you've been paying attention to the big decisions emanating from the Supreme Court in recent years, you know that this evolution is a struggle to be consistent with founding principles, to overcome weaknesses in other parts of our governments or society at large, and to frame good law on new and sometimes unanticipated topics. The subject for our lecture today, the application of the Fourth Amendment's protections against unreasonable searches and seizures to data on cell phones, is probably a very good example of a sometimes unanticipated topic. As technology has advanced, so too has the challenge of understanding just what constitutes reasonable. Smartphones are the most recent challenge, but they won't be the last. In her lecture today, Hey, You Can't Just Look in There, Current Fourth Amendment Issues Regarding Cell Phone and Email Privacy After Riley v. California, Professor Jennifer Sargent will discuss the vexing issues of constitutional rights to privacy in the digital age. Professor Sargent is a visiting associate professor in the writing department at Dartmouth and a faculty member at the National Judicial College in Reno, Nevada. She's previously been a member of the faculty at Vermont Law School. She's served as a district court judge in New Hampshire and has also served as Chief Disciplinary Counsel for the New Hampshire Supreme Court Attorney Discipline Office. Professor Sargent graduated from Emory University in 1989 and Suffolk University Law School in 1992. After law school, she served as a judicial law clerk to the judges of the District and Superior Courts of Vermont. She spent 8 years as a criminal defense trial and appellate attorney in New Hampshire with the New Hampshire Public Defender and New Hampshire Appellate Defender. Ladies and gentlemen, please join me in welcoming Professor Jennifer Sargent.
Hi, everybody. Welcome to my talk. I have this recurring nightmare that my husband and my in-laws would be the only people in the audience, so I'm eternally grateful for you showing up. Thank you very much for that really excellent welcome, Professor Samwick. I'm very flattered to be asked to give such an important talk today. But I notice that there are a lot of students in here whom I know who've taken my classes before, and I just want to say that I give out pocket constitutions in my judicial opinion writing class. So now some students have two pocket copies of the Constitution, which is fantastic, right? You can never have too many pocket Constitution copies, especially because Meredith over there, who led all the first year trips at the lodge this year, at the Moosalak Lodge, apparently there was a lull in the action at one point, and she whipped out her pocket Constitution from my class, and they played What is Your Favorite Amendment and Why? True story. Very Dartmouth story, true story. But, you know, however you use it, you got to use it right? So speaking of using the Constitution correctly, we're going to talk about Current Fourth Amendment issues regarding cell phone and email privacy after Riley versus California. There we go. All right, so we start with the Fourth Amendment. The right of the people to be secure in their person, houses, papers, and effects against unreasonable searches shall not be violated, and no warrants shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fourth Amendment has really taken a turn in American jurisprudence. I'm not going to say for the better or for the worse, but the interpretations of the Fourth Amendment by various judges and justices have been different, polar opposite, unusual, unpredictable. However, I think that we can all agree that they're always interesting. And before I go any further, I want to give you the flavor of the talk in, I hate to say it's a joke, but it's a joke. Now, warming up an audience with a joke is like, number one, don't do it. Because if you're not funny, nobody wants to listen to the rest of your lecture. Well, I tell this joke at the National Judicial College to the judges that I teach before we do my Fourth Amendment section, because they get so worried about getting the answer right because the jurisprudence is all over the place. So I'm just going to tell you the joke, and you'll get it. I mean, you heard the joke, and you don't have to listen to the rest of the conversation because you'll know exactly what the talk is about. And really what it comes down to is this. There were two judges, and they went duck hunting together in a boat. And they're out, and it's early, it's dawn. They're not in the duck blind, they're in the boat, and there's mist on the water. Both of them are sitting it's very quiet. And in the distance, the appellate court and trial court judges hear quack, quack, quack. And the appellate judge picks up his shotgun, and he says, "It looks like a duck. It quacks like a duck. I think it's a duck." Duck is long gone. A little while later, quack, quack, quack. And the trial court judge, she picks up her shotgun and bam, bird falls into the water. And she says, "I hope that was a duck." That is the life of a trial court judge. Honestly, I can tell you. I am no longer a trial court judge. I do not pretend to be. I resigned voluntarily to become the Chief Disciplinary Counsel for the state of New Hampshire, which is sometimes called Bar Counsel, the lawyer who disciplines lawyers for improper ethical conduct. Well, I don't actually do the disciplining, I just recommend the discipline. And then it's up to the PCC to decide if they agree with me or not. But in any event, when I was a judge for 8 years, I was in the trenches. And by the way, there are some judges, or a judge at least, here today. And I hope I have the support of the judge, because it's always helpful to have an ally and not an opponent. But in any event, I found that what I learned in law school, and even what I learned in the practice of law as a public defender, and then what I learned at judge school, didn't really help. It was almost like what I learned in Lamaze class when I was pregnant, that breathing. Like when it actually came time, that doesn't work. That doesn't help. So I'm telling you, you're in the moment, you gotta shoot the duck, and you just have to sometimes think very, very fast and hope you've got it right. So I want you to think of the urgency that these judges that I'm going to talk to you about have to face, because it's a hard job to do, and it's a really hard job to do well, and it's an incredibly hard job to do right. The Fourth Amendment is grounded on reasonableness. It's the ultimate touchstone of the Fourth Amendment, and law enforcement must execute searches pursuant to search warrants in a reasonable way. Well-established law. The modern framework of reasonableness requires a cost-benefit balance. So the court balances the nature, the judge balances the nature and quality of the intrusion into the privacy of an individual and balances it against the importance of the governmental interest alleged to justify the intrusion. So it's, all right, we have the individual, we have the government. Government doesn't have any protections, individual has all the protections. Government wants some of what individual has. Can the government step into the individual's space, invade their privacy legally? Sometimes the answer is yes. How much of an intrusion is usually determined on a case-by-case basis. So, what were cell phone searches like pre-Riley? And I'm not going to tell you about Riley yet, because I want to tell you about the history of searches before Riley. Well, before Riley, and I will tell you the punchline now. Riley versus California, the Supreme Court unanimously held that the government has to get a search warrant. Law enforcement must get a search warrant to look at, search any cell phone after an arrest. All right? Before Riley made that statement, searches were usually of cell phones were usually conducted without warrants. They were done as warrantless searches incident to arrest. Now, there is an exception to the Fourth Amendment for warrantless searches, and that is that sometimes if someone is arrested, right then and there, the law enforcement can engage in a search. And the reason they can do that is twofold, actually. So that means there are two reasons. One is for officer safety, a pat down to feel if there's any weapons or other things that might endanger the officer. And the second thing is for evidence preservation, some evidence that the officer may discover that will not be preserved. A custodial arrest of a suspect based on probable cause is a reasonable intrusion under the Fourth Amendment, the court has held. So that the intrusion is lawful and a search incident to arrest requires no additional justification. So just by virtue of being arrested, the person is subjected to a pat down of his or her person and the seizure of anything that compromises officer safety or evidence that might somehow not be preserved. Well, now we have our cell phone searches post-Riley. Here is the case. We hold, that means that's the rule, we decide, that officers must generally secure a warrant before conducting such a search. This decision was a very important decision. Some would say an obvious decision. But for those of us who really follow Fourth Amendment jurisprudence and the Supreme Court currently, I have to say that I don't put money on anything anymore. Never know what's going to happen. The reason that the Riley court said this is because they found that cell phones really don't present a concern for a threat to officer safety. If Apple makes it any bigger, it might. But right now, it's not a threat to officer safety. There's no real reason to believe in a threat of destruction of evidence. Now, this was the second reason, the reason that was really litigated most heavily. I mean, it's not arguable that there's an officer safety issue with a cell phone. But what about the fact that data can be erased, wiped out? Well, the Supreme Court said there are actually ways of dealing with these things. For remote wiping, disconnect the phone, take the battery out immediately. For encryption, isolate the phone immediately from radio waves in something called Faraday bags. Now, Faraday bags are the thing that your E-ZPass comes in, and you keep your E-ZPass in there. It's the metallic-looking bag that keeps you from setting off your E-ZPass when you don't mean to. All right, so in our Supreme Court case of Riley, the Chief Justice Roberts, delivered a unanimous opinion of the court. Justice Alito wrote a concurring opinion, but he wrote an opinion that was very much in agreement. The case actually was the consolidation of two cases. It consolidated Riley versus California with a case called United States versus Worry. And both Riley and Worry involved defendants initially seized in motor vehicles and arrested at the scene. Now, this is an important thing to recognize because a lot of the Fourth Amendment jurisprudence surrounding search and seizure of vehicles, things that happen in motor vehicles because motor vehicles move, there's a lot that can happen that can't happen in, say, a house because of the mobility. And they were arrested at the scene. In Riley, the police officer stopped Mr. Riley for driving a car with expired license plates, and then further investigation revealed he had a suspended license. So the police there and then impounded the car. He wasn't under arrest for that yet, but they impounded the car, and they did what's called an inventory search of it, which is a standardized search on paper. It's all laid out. It has to be laid out in advance in order to inventory the car, the contents of the car, so no one can come back later and say, hey, the police stole something in the car, or moved something in the car, whatever. So they inventory searched the car, and lo and behold, they found 2 concealed loaded handguns. The officer then searched Mr. Riley, incident to arrest. So that means they arrested him, they did the pat down, and they found items associated with the Bloods street gang. The officer discovered a smartphone on Riley, looked at it, saw names in the texts and the contact lists that had CK in front of those names. CK being the moniker Crips Killer, which is another way to say a member of the gang Bloods. So upon further inspection at the police station, a gang specialist detective took over and went through the phone in greater detail. The detective later testified that gang members often photograph or videotape themselves with guns. That is a reason why they would want to look at the phone and suspect there might be evidence of gang activity in the phone, something that leads to probable cause. Although there was, according to the officer who testified, a lot of stuff on the phone, particular files that caught his eye included videos of young men sparring while someone yelled encouragement using the moniker Blood. The police also found photographs of Riley standing in front of a car they suspected had been involved in a shooting a few weeks earlier. So they then charged Mr. Riley in connection with the earlier shootings that had occurred in the car they saw him in front of in the picture, and also with possession of concealed and loaded guns. So they charged him with assault with a semi-automatic weapon, attempted murder, and possession of concealed weapons. It's safe to say that he was in a lot of trouble. And it was all from that, started with that cell phone. In U.S. versus Worry, the police observed Mr. Worry make an apparent drug sale from a car. The officers arrested him, took him to the station, searched him, and found 2 phones on him, one of which was a flip phone. The flip phone kept ringing every so often. And My House displayed on the external screen. The police opened the phone, saw the wallpaper set as a woman and child, and pressed a button to find the phone's phone number. Then they did a reverse trace, found the address that the phone number matched to. They went to Mr. Worry's, they went to the apartment building, they found a mailbox with Mr. Worry's name on it, looked through the window and observed a woman whom they believed was the same woman in the picture on the wallpaper of the cell phone. Never put pictures on your wallpaper, apparently, is the moral of the story. They then secured the apartment, got a warrant, so they didn't enter the apartment, obviously, but that all was probable cause to get a warrant, where they then went and searched the house and found drugs, guns, and cash. So looking at the privacy interests of the individuals, it's really well-established Supreme Court precedent that arrestees have reduced privacy interests when they're taken into police custody. Their privacy interests automatically reduce by virtue of the fact that they're in custody.
Does that mean they're arrested or they're in custody?
When they're in custody, they're arrested.
So why do I give up rights if I haven't been arrested?
Well, if you're in custody, the argument is you are arrested, and therefore you have given up your rights automatically.
So even if in the end I have not committed a crime, I'm still giving up rights as soon as I go into custody?
Yeah, once they hold you in custody. But custody is also a good thing because a lot of rights attach. More rights attach if you're in custody than not, like Miranda, for instance, which is important. So we of the defense persuasion kind of like the word arrest because it really gives custody. I mean, we know custody's there. And that moves us right along. All right, so it's established that the person is in police custody, has privacy interests that are lessened. But the Fourth Amendment doesn't just go away. I mean, the Fourth Amendment protections are still there. So to what extent are they still there? The Supreme Court has said, and Riley quoted this, that the fact that an arrestee has diminished privacy interests does not mean that the Fourth Amendment falls out of the picture entirely, because not every search is acceptable solely because a person's in custody. To the contrary, when privacy-related concerns are weighty enough, a search may require a warrant, notwithstanding the diminished expectations of privacy of the arrestee. Now, this is very strong language from the Supreme Court. You don't often see the Supreme Court really making such a statement in the face of deciding where the bright line rules, where we draw the lines about where and when and how rights are diminished. It's usually a fluid kind of case-by-case analysis. But here, the Supreme Court said, just because somebody is in police custody does not mean that a warrant may not be required. So those of us who are reading this, who wanted, we followed the analysis. When you see language like that, as a criminal defense lawyer, you know something good is about to happen. And as a law enforcement officer, maybe something that will make your job a little harder. So what is it about cell phones? Well, the Riley court went so far as to call them mini computers, which is remarkable, because by calling it a mini computer, they're really extending this analysis to more than just cell phones. They're extending this analysis to all things computer. Now, what are all things computer? There's a lot out there, and there will be more. But remember, this is precedent now. So all things computer, anything that becomes computer, will fall under this. Very strong language. And it's a mini computer that just happens to be able to make phone calls. I wish somebody would tell my son that. The Supreme Court essentially says that cell phones / mini computers can create a narrative. And this is a really interesting part of the opinion, because without using the word narrative, that's my word as a writing professor, this is what the Supreme Court says a mini computer does. is it compiles and puts in one place so much information about a person that you can actually write the story of their private lives. It's like this is your life in an electronic device. If you remember the old game show, we just put it in the cell phone. That's what you can find. So because the Supreme Court said that this conglomeration of information stored on the cell phone creates a detailed picture of an individual's life, the individual has a privacy interest in all that information. The Supreme Court also noted that there is an element of pervasiveness that characterizes cell phones but not physical records. And that is that so many people have cell phones. In fact, the Supreme Court cited a statistic that said more than 90% of adult Americans keep their lives on their cell phones. That's an incredible statistic. But if that's the case, then what they're talking about is this isn't just a few people who have these cell phones that tell the stories of their lives. We, citizens of America, we are our cell phones. And most of us shall never separate our private lives from our cell phones. Which brings up, by the way, I think a much more interesting but separate Fourth Amendment question about what is a reasonable expectation of privacy. But that's my next talk someday. Further complicating the scope of the privacy interest is where the data is kept, on the phone or in the cloud. Is the data on the device or is it accessible through the device? What may not be on the device? All the emails. They may be in the Google Cloud or the Gmail Cloud, right? Which is Google Mail. But it's not really easy to tell at first blush, first glance, unless you're very, very savvy about computers, what information is where. So search warrants. Who applies for a search warrant anyway? Now I'm bringing you down to shooting the duck. Who applies for a search warrant? Law enforcement. A judge just doesn't sit down in her chambers and write a search warrant. The officer doesn't come in and say, I'd like a search warrant, and you say, sure, no problem. The officer has to apply for a search warrant, and there are forms that the officers use, and a lot of times they have a template that they use and they fill it in. They very rarely craft an original application every time because there's certain language in the templates that has to be used, et cetera, and it's just easier that way. But like any form, sometimes if an officer or anybody relies too much on a form that is pro forma, that is a template, then some of the uniqueness and subtleties that will appear in the case disappear. In other words, law enforcement might miss something. They might not ask for something specific. What happens after law enforcement or the government officials draft the application? Well, there are a couple ways. This is actually how it works. Either law enforcement comes to the courthouse if it's during the business day, and we encourage law enforcement officers to do this during the business hours, and they ask to see the judge, and they say they have an application for a search warrant. And the judge with jurisdiction will then meet with that law enforcement officer, put that law enforcement officer under oath in chambers, and question the officer about the application. So the judge will read the application, the judge will see what's requested, will ask questions to fill in some of the gaps for probable cause if they exist. It's very, very important that when a judge is asking questions, anything that happens that's not in that application, a judge should write it all down. Because the last thing you want to be accused of as a judge is signing a warrant for something that they didn't ask for. Maybe they asked for it during your conversation and you added it in. Or worse, helping them figure out what to ask for. Judges are Switzerland, right? Neutral. No, they're not on the prosecution side and they're not on the defense side. After the judge decides whether or not to grant the application for search warrant, the judge or the judicial officer writes the search warrant up. And search warrant applications are reviewable by lots of different types of judicial officers. Some by statute, by law, in fact, all by statute and law. But some individuals who are not truly what we would think of as judges, say justices of the peace, have certain powers bestowed upon them by the legislature in certain states. So in some states, there are justices of the peace or others who are not officially judges who are imbued with the power to write search warrants. And it happens a lot in rural areas or states that have large territories and a lot of distance between judges. In the National Judicial College, we train a lot of judges from Alaska. I truly did not appreciate how hard it is to be a judge until I heard how hard it is to be a judge in Alaska. First of all, you fly your own plane from jurisdiction to jurisdiction. Most judges fly their own planes from jurisdiction to jurisdiction. It's amazing. Well, I think most people in Alaska fly their own planes, but it's incredible. How do you get a warrant to a judge in Alaska, by the way, if you don't have your plane handy and it's not during business hours? Well, you can submit, law enforcement can submit an electronic request. And many judges now, including the federal magistrate judges and judges on the federal bench, are using iPads that are specially equipped with software specifically for warrants. So they're doing warrants by iPad. I think that's awesome. I want one. One of my very dear friends is a federal judge, and I did ask if I could have her iPad, and she said no. All right, what is the reviewing officer looking for? You know, it's probable cause to believe that there is fruit on that tree, that there's evidence that will link the person to the offense that they are suspected of committing. The warrant, the Fourth Amendment has a specific clause called the particularity requirement. It's in the warrant clause. And it says, and particularly describing the place to be searched and the persons or things to be seized. So the Constitution says the application and the subsequent warrant have to be particularized. That there can't be just this random general warrant, this random general search. What law enforcement wants to look for, law enforcement has to identify particularly, and law enforcement has to identify it particularly and state it to the judge. There's a lot of case law on particularity. Our cases have recognized, this is Riley, so this is the current case we're talking about. There's a quote here. Our cases have recognized the Fourth Amendment was the founding generation's response to general warrants and writs of assistance of the colonial era. A writ of assistance is a paper that assisted the British in rifling through all of the American stuff. And that allowed British officers to rummage through the homes in any unrestrained search for evidence or criminal activity. So opposition to such searches was in fact one of the driving forces behind the revolution itself. The Supreme Court is going whole hog on this, right? Riley, I mean, this is Fourth Amendment law with a lasso and a steed. Riley's conclusion, second to last paragraph. I love when they wax eloquent like this. Modern cell phones are not just another technological convenience. With all they contain and all they may reveal, they hold for many Americans the privacies of life. The fact that technology now allows an individual to carry such information in his hand does not make the information any less worthy of protection for which the founders fought. Our answer to the question of what the police must do before searching a cell phone seized incident to arrest is accordingly simple. Get a warrant. Dun, 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 dun. Do you hear the music? Do you hear all of the fanfare? Do you see the parade? This was great. And the day that this case came out, this was just incredible. I mean, people were really going nuts over this particular conclusion that the Supreme Court had reached. It's so patriotic. Well, guess what I heard as a former judge? And it's not because I didn't think it was a really great ruling. It's because I immediately went into my Woody Allen mode. All right, and it's not the funny. It's, the headache that's really a brain tumor, right? Okay, so I think that this great thing is really kind of a boil that's waiting to get bigger and fill with fluid. Because I start to think about particularity and reasonableness. That's the first place my head goes as an ex-judge. Is to that Fourth Amendment. Okay, let's get a warrant. What do we need? Particularity and reasonableness. Got to have them. For all the reasons I've just gone through. How would a judge approve a warrant application and draft a warrant that considered both? Well, don't judges do that all the time? Yes, but we're talking about a cell phone. We're talking about computers. We're talking about data. It's kind of amorphous. How would a law enforcement officer know what he or she is looking for? We need some really, really well-trained law enforcement to ask for what they need if there's this particularity and reasonableness requirement. This is hard. This is getting harder now. The boil's getting bigger. How much rummaging could law enforcement do, especially if they don't really know what they're looking for? And to what extent could or should a judge involve herself in guiding and subscribing a warrant? What happened to Switzerland? So this is the judge's reality. Judges are usually not experts in technology. There are really severe time constraints on judges, for the most part, especially during the business day when you're also running a docket. It's hard to have a 2.5-hour conversation about a warrant application. You want to get it done. The process is called ex parte. That means that there is no defense side. No one to defend the other side of the person, the accused, or the person they hope to accuse. It's just between the judge and law enforcement. Separation of powers. Judges are not law enforcement. Judges are judges. Now, many judges come from a law enforcement background. Many judges who do a lot of criminal work come from a law enforcement background. It's very interesting to watch a law enforcement officer who is used to dealing with judges who come from a law enforcement background attempt to present their application to a judge who had a criminal defense background. Fun, and they did a great job, but sometimes they would come in and kind of expect the rubber stamp. Some judges who come from law enforcement backgrounds, by the way, are harder on the law enforcement than on anyone else. They expect more. So once a judge unconstitutionally interferes with a person's rights, it's hard for the judge to undo it, right? And make the person whole again. This is like the judge's terror. You don't want to interfere unduly with someone's rights as a judge. That's the worst thing you can do. That's the crime. That's not why you become a judge. So, the bottom line, and this comes from a case out of the Vermont Supreme Court in 2012, before Riley, because this, what I'm talking to you now, going to be talking to you about, started to bubble up even before Riley, but Riley makes it very urgent. The Vermont Supreme Court said there, and this is pretty well accepted, that there's this interplay between probable cause, particularity, and reasonableness that judicial officers reviewing a warrant application must consider in authorizing a form of privacy invasion. Great, so we have this balancing test that we have to perform. Probable cause, particularity, and reasonableness. It still doesn't sound that hard. How does a judge achieve that in a constitutional way? Well, I say it sounds like a goofy question, but it's not, because it's harder than it looks. You got to start with the principle that we can't have law enforcement engaging in big fishing expeditions, meaning it's what the 10th Circuit referred to as general exploratory rummaging in U.S. versus Carey. General exploratory rummaging. I love when judges use those types of phrases. They're really great, if only to just repeat for no reason. Because modern computers contain a plethora of private information, exposing them to wholesale searches presents a special threat of exposing irrelevant but damaging secrets. Well, that's the whole point of keeping things private, right? Because it's nobody's business what's there, except the person whose it is and who the person whose it is chooses to share it with. That's privacy. Once we let the rummaging begin, we let privacy be invaded. What if someone has gone on a search engine, WebMD for instance, and looked up all of the sexually transmitted diseases, one after another? Does that mean that the person is involved in any kind of criminal activity? Does it mean that the person is sexually active? Does it mean that the person has sexually transmitted diseases? Or that someone that person knows has sexually transmitted diseases? Maybe it means nothing except the person wanted to know what they were. But people make judgments about what they see and jump to conclusions, which is one of the reasons why courts think that it's important to keep all of this private. Because people shouldn't have the information to jump to those conclusions unless the person who owns that information wants to give it to them. The accuracy of the particularity requirement, this is where the rubber hits the road for the judges. It's a practical accuracy. It's not a theoretical accuracy. It's practical practicality. It's practical particularity. How do we make it practical on a written level? How do we draw it up so that it's particular? Particularity is measured in practical terms, said the Vermont Supreme Court. to explain the standard to determine whether a warrant describes a place to be searched with sufficient accuracy is one of practical accuracy rather than technical nicety. I like that very much, because what they're saying is that it's not just a nice theory of privacy, like we actually have to make this work. So enter the concept of Exantiinstructions. Oh my gosh, here comes the Latin. Stop being a lawyer. Well, I try to avoid the Latin at all costs. I was scarred by it deeply as a child. 7 years of it. And pretty much all I can do is know when I need to look up something in Black's dictionary. That's what 7 years of Latin told me how to do. Look up stuff. What if, in the face of a broad warrant application, a judge seeks to guide or limit or compel or otherwise control law enforcement's search process? What if the judge says, I'm going to guide you, law enforcement, to help you particularize your search? I'm going to give you some paths to follow, maybe some ground rules. The instructions on how to conduct a search before the search is to take place is called an ex-ante instruction. Now, some scholars call them ex-ante restrictions. There's a really great semantic difference between what an instruction is and what a restriction is. So it's really, you can tell now, we've got a couple sides of the coin that we're dealing with, right? It's either an instruction, which means good, do it, tell people how to do it, or it's a restriction. Don't do that, it binds somebody. So what does an ex-ante instruction look like? Well, the application to search a computer belonged to John Doe would go something like this. The warrant would say it's granted with the following conditions. And I'm just going to give you a whole host of examples. And these are real examples of ex-ante instructions that judges have in the past used. The police shall waive reliance upon the plain view doctrine to seize any criminal evidence electronic record not authorized by this warrant. Wow. Excuse me, okay, that's fine, but if you want to do that search, you have to actually waive a legal doctrine. Wow. And by the way, plain view is really important to law enforcement in searches. Because what it means is that law enforcement, even if they're not looking for something related to anything that's not in the warrant, if they come upon it and it's obvious that it's illegal or it's contraband, they get to seize it, even if it has nothing to do with the warrant. Now, there used to be a third prong to the test. Plain view doctrine used to also involve inadvertence, meaning they had to come upon the evidence inadvertently. Supreme Court's gotten rid of that. So all now the officers have to do is come upon contraband that they can immediately identify as contraband, and they can seize it. Well, what if you tell a police officer, you can't rely on this plain view doctrine, this exception to the warrant, the exception to the Fourth Amendment, as stated by the Supreme Court? Whoa, okay, Judge, you may have just overstepped your bounds a little bit. It's arguable. The Vermont Supreme Court, by the way, found in that appeal case, in the case that I cited, that instruction was overreaching. And when the Vermont Supreme Court says that instruction is overreaching, I don't think you're going to find a lot of courts that are going to say otherwise. Specially trained computer personnel must conduct the search behind a firewall and provide to police only digital evidence relating to the offense of whatever the person is suspected of doing. That's an example. Specially trained computer personnel must segregate and redact evidentiary data from surrounding non-evidentiary data. Police personnel who are involved in conducting the search under Condition 2 may not disclose their findings to prosecutors or investigators. Those conducting the search must limit The search protocol to methods to uncover only information for which the state or government has probable cause. Search personnel shall copy and provide police with only evidence relevant to the targeted alleged offenses. Theoretically, this is all sounding very good. Practically, I want you to think about it. Search personnel shall not use hashing tools or similar search tools without specific authorization of the court. Oh man, you better have a judge who knows how to use hashing tools. Most of the judges that I've dealt with really don't even know how to use their cell phones. Never mind what hashing tools are. If the police receive any non-responsive data from the search personnel, the police shall return it to the search personnel and inform the court immediately. Thin blue line. The police shall destroy remaining copies of electronic data absent judicial authorization otherwise, which is very typical. That's a typical one that's in almost every warrant already. And the police will file a return. This is also in every warrant. And a return means a report that reports what evidence was seized, where it was found, etc., within whatever time limit to indicate precisely what was obtained. Those are all ex-ante instructions. They seem like a really interesting idea. They could be helpful. Do you see how maybe they could be helpful? They could be helpful because they could steer law enforcement away from just rummaging. We could move law enforcement towards the things that they want. Well, first of all, for a judge to be able to write these ex-ante instructions, I would submit to you that a judge has to be pretty darn savvy when it comes to technical stuff. And most states, I can't speak for the federal government, but most states do not regularly train their judges because they don't have the resources to do it. Most judges who attend the National Judicial College attend on scholarship, not because their state has the ability to pay. Well, let's just have a whole retreat where we take the judges away for 2 days and teach them all about computer science. Honey, you want that job? Ex-ante instructions are a new-ish idea, but they're not grounded in legal precedent. They really appeared on the legal radar. I mean, judges have kind of been doing it for years, but they really appeared on the legal radar. In 2009, in a case that is called the U.S. Comprehensive Drug Testing case, and it's a huge case about digital warrants, digital evidence warrants. And it has a tortured history. I could spend an hour telling you about it. But what's important about it is how ex-ante instructions came to the forefront because of this case. And it was because of Chief Judge Kaczynski from the Ninth Circuit Court of Appeals. Chief Judge Kaczynski is a very well-known judge, very prolific writer, very outspoken advocate, extremely opinionated, and is erudite. So he's good. But he's got positions on things that you might not agree with. One might not agree with. It was in the CDT case in 2009 that Judge Kaczynski wrote the panel opinion, and he wrote the last few pages called Concluding Thoughts. Because we all have so much time that now I'm just going to give you my concluding thoughts. And in that section, Judge Kaczynski said everyone's interests are best served if there are clear rules to follow that strike a fair balance between the legitimate needs of law enforcement and the right of individuals and enterprises to the privacy that is at the heart of the Fourth Amendment. So Judge Kaczynski went on to outline ex-ante instructions. He actually wrote 5 as examples and said, here, judges, here are 5 good ones. Use these. Hey, one of them was the plain view one. Waive your plain view doctrine. Law enforcement. Did he open the floodgates to all these ex-ante instructions appearing in 2010 in all the warrants? Well, I would say he did not. But what he did do was he made the first really super public, overt suggestion that ex-ante instructions were not only appropriate, but they were good, helpful, constitutional practice for judges to engage in. Now look, let's go back to the judge being not so technically savvy. It's very helpful, just like a template is helpful, to have a chief judge of the Ninth Circuit Court of Appeals say, hey judges, here's 5 examples that you can use in these computer warrants. You know what, my guess is the judge in Kotzebue, Alaska could, kind of really use that kind of help, because that judge hasn't been trained in anything computer, except for the control panel on his or her plane. So there's a school of thought that now, there are 2 schools of thought with regard to these ex-ante instructions. And I'm almost done, so don't worry. It's accepted law that judicial officers, this is the first school of thought, have the authority to describe in general terms what sort of invasion is authorized. I mean, we've had this discussion many times. The Supreme Court has said no knock entry is in the judge's discretion, meaning a judge can say, law enforcement, you don't have to knock and announce your presence before you go in and search, because that might result in destruction of evidence. So in the right situation, we can make that a little different. Or, for instance, what time of day or night, or whether day or night matters. There were search warrants that, for instance, I had a police department that regularly appeared in front of me in a county that liked executing all its warrants at about 2 in the morning. After I found out about that pattern, I started to think perhaps that there was no reason to execute all of those warrants at 2 o'clock in the morning. So I started putting, you have to do it during daylight. That was an ex-ante instruction. But the Supreme Court had ruled that's fine, because that is reasonable. That goes to the reasonableness problem. So the above cited examples are ex-ante instructions, and what the school of thought is in these kinds of warrants, these digital warrants, it doesn't make any sense to wait for ex post review, meaning a motion to suppress or a motion to dismiss or some kind of action to get rid of what the police found once the police have already done the search. That's an ex post review, and that's what we have traditionally in our system, is ex post review. We don't want to have the search happen and then have to deal with it, because nobody knows what they're looking for when it comes to computers, right? So instead, the school of thought is that ex-ante instructions ensure the proper scope of the privacy invasion, and they are part and parcel of the particularity requirement. School of thought number 2, completely the opposite. Orrin Kerr, who is a really well-respected law professor, scholar at the George Washington University School of Law, he wrote the seminal law review on this practice from an academic standpoint. And by the way, that's the law review article. And by the way, if you want this PowerPoint, I'm happy to share it with you. So the Kerr argument is that reasonableness is an ex post assessment, meaning the search has to happen first, and then we decide whether the search was reasonable after it happened, because we now know what happened. How can you decide if the search was reasonable if you haven't done the search yet? So he says reasonableness, this whole concept of reasonableness for Exantiinstructions is completely out of whack, that it doesn't exist. And what do we know about the touchstone of the Fourth Amendment? What is the touchstone of the Fourth Amendment? Reasonableness. So you can see that his argument is that, you can't have ex-ante instructions. You just can't have them. And he calls them ex-ante restrictions. All limitations and authorizations for actions involving the execution of search warrants have to be devolved on a case-by-case basis. Knock and announce. That's a malleable standard. Guess what? That came from cases where the search was done, where the evidence got destroyed, and the police officers went to the court and said, see, that's what's going to happen if we knock. Doesn't help the situation at hand, but provides instruction for post-searches. All of the rules and standards handed down in ex post litigation are when the court and the appellate record has been established, and then judges can look in that and announce whether the procedure was reasonable in light of all the facts. The Kerr argument also makes a really interesting argument about creating two different sources of rules regulating warrant execution. And that is, and this should be obvious by now, okay, now we have two sets of rules. We have the Fourth Amendment, and we have the criteria that the judge or justice writes down that the police have to follow. And also, Mr. Kerr, Professor Kerr, believes that ex-ante restrictions, they introduce constitutional error. They just beg for constitutional error. Because even though they reflect a good faith effort to identify what will be constitutionally reasonable, you can't do that without the facts. So judges, you're going to make assumptions in your search warrants that are going to turn out not to be true. And those assumptions are going to cause constitutional error, an unlawful invasion of privacy rights. Oops. So Kerr's point is that reasonableness is the only determinable when a judge can weigh the execution of the warrant against the facts as they actually occurred. So what about ex-ante instructions after Riley? Well, we are going to see a lot more digital search warrants, aren't we? Because now every single cell phone taken off an arrestee requires a search warrant. They're going to become bread and butter search warrant applications. There's going to be a load of them. We're going to have untrained law enforcement and untrained judges dealing with these bread and butter search warrants. So away we go. Email is the way many of us communicate now. Law enforcement will want this information. And now they have to ask for it. They can't just go and get it. As a champion of the Fourth Amendment, I say, yay. As a former judge, I say, oi. And there is a federal magistrate, I'll leave you with this. First case I could find after Riley came out on July 18th, 2014. Magistrates, by the way, don't usually put their search warrant process on paper. This magistrate did, and he's a magistrate, Judge Gornstein, and he's in the U.S. District Court for the Second District of New York. So he's in the city. He's one of the most powerful federal courts. Here are some highlights from what he did. I'm going to distill it for you. Judge Gornstein not only said, I'm not giving any ex-ante instructions, but I'm going to authorize the government to go to Google and get every single email and piece of information in a Google account that's attached to a particular Google address. That address right there, that's the case. No protocol. The judge just said, I'm doing a very pure care analysis. Unfortunately, when you read this magistrate's reasoning, it doesn't square well with Riley. So we have two really good competing schools of thought about ex-ante instructions. And now we get to see the magic happen. Sit back and watch. Now that you're educated, pay attention to this, because this is going to be bubbling. We're going to get to boil now. Where will judges go with these ex-ante instructions? We don't know. I don't know. I know they're going to go both ways, and I know we're going to see a split in the circuits, because this has ideological potential. Riley requires a warrant, but it may allow judicial officers to draw what some people say are general warrants. Riley didn't really bring any practicality to the table. It just brought the theoretical concept and protection of the Constitution, which, you know, that's what the Supreme Court's job is to do. They're not the ones who have to be practical in the sense of figuring out how the judges at the lower level are going to do it. But having been the judge at the lower level, it's really nice to have a little guidance. And if Judge Kaczynski is going to be the one giving me guidance, I really don't want Professor Kerr's argument to make so much sense. So you can now turn on your own cell phones and check your email. Be careful. I think there's a Q&A. This is the point where if you want to leave, leave. You don't have to stay for the Q&A. I never stay for the Q&A, by the way. But if you have any questions, I'd be happy to answer them. All right, let's begin the Q&A. Yes, sir. You have a question for me?
I'm a retired California Superior Court.
Thank goodness I got somebody legit in this audience. You tell me what the story is.
I never in 10 years of Superior Court service wrote a warrant for a police officer, a deputy sheriff, a California highway patrolman. And I don't know whether there is an applicable statute in the California Penal Code, but I know of no judge, and
That
I
writes-
practiced
you're telling me that writes
whoever
warrants.
did that. Therefore, I am curious as to whether you have a reasonably good idea of how many states encourage a magistrate, a commissioner, a judge to do that, and what the practice or the rule or U.S. code provision may be in the federal courts.
It's an excellent point, Judge, and I'll tell you why, everybody else, why it's an excellent point. When the judge says he never wrote a warrant, what he's saying is he was never asked and never given the power to and never engaged in the practice of sitting down and actually taking the application and writing out his own warrant. Am I correct?
That is correct, because the warrant was presented concomitantly with the affidavit.
Correct. And that is actually the more prevalent practice in all the states and the federal court, is rather than the judge personally writing it, the judge signs off on a pre-written warrant drafted by law enforcement. It's the wish list warrant, we call it.
Or doesn't sign off.
Or doesn't sign off, or amends with, in discussion with the police officer, might cross a couple things out or add in some language, which was my point about if you're having this ex parte conversation, judge, you write everything down that you talked about. But it's true, judges don't necessarily write warrants, but in the parlance that we use, especially in National Judicial College, we call it writing warrants when you sign off on warrants, because it becomes the judge's work product once the judge signs the warrant. It becomes the judge's warrant. Would you agree with me?
Yes.
So in that sense, I would say that the practice that the judge brings to our attention of signing off on a warrant application and the wish list warrant is really not writing the warrant in the sense of authoring it, but writing in the sense of adopting it. Fair?
Yes.
Great.
So when judges, should I wait for the microphone?
That would be great.
Okay. So when judges can write sweeping ex-ante instructions like the one you presented, let's just go in and take all of his emails from this particular email account.
Okay. Well, that wouldn't be, you mean it would write, that wouldn't be a sweeping ex-ante instruction. That would be not writing an ex-ante instruction at all and not limiting the search at all.
Right.
Saying, law enforcement, go for the whole Google mailbox.
Yeah.
Anything attached to that email address. So that would actually not be writing an ex-ante instruction. Go ahead.
All right. Yeah. So doesn't that mean that in writing any ex-ante instruction, that judge is inherently working for the defense? If the lack of any ex-ante instruction is obviously all in the prosecutor's favor, all in the law enforcement's favor, would any ex-ante instruction, particularly the ones that you mentioned, be inherently protecting the, like if they're only protecting the arrested person's rights, are they inherently one-sided?
They're one-sided, but I'm going to ask you to look at it from a different perspective. If I were law enforcement, I would not want judges writing ex-ante instructions. I don't want a judge who's supposed to be Switzerland telling me how to go about finding what I'm asking for. Judge, I'm asking for this. Either give me permission to get it or don't. I have probable cause to ask for it. Don't start messing with my process, especially if you don't know enough about the process to write an ex-ante instruction that lets me find as much as I can find under that warrant, if you grant it. So when you say it's biased towards the defense, I would argue, or biased against the defense, I would argue that it could be seen as biased towards the defense and biased against the prosecutor. If I were the prosecutor, I'd take one look at an ex-ante instruction warrant and go running for emergency relief. In fact, probably both parties would just run for everybody's going to the courthouse. It's a race. This gets into whether judges should be interfering with anything outside their role at all. The Supreme Court has said that certain things, like a judge's determination of whether or not there should be a knock and announce before the search, whether or not law enforcement can bring media along with them during a search. That's a bright line rule. The Supreme Court has said no, absolutely not. With this bright line rule, no media goes with law enforcement during a search. Those are all ex-ante type instructions. But the thing is, they've been generated, they've been written during an ex post assessment process. They've been generated after the court has been able to look at how the search played out and all of the things that actually happened. And whether or not, say, the media's being there hindered the defendant's Fourth Amendment right in any way. So it's really a question of not, are they sweeping ex-ante instructions? The question may be, should they be done prior, should they be implemented prior to the search as a guide to help particularize that warrant? Or should we just wait until the court, any court, gets around to analyzing a certain warrant condition in an ex post review and see if the court says that's reasonable? Because at that point, it seems that an officer could use that information. Does that answer your question?
Yeah.
It's a little chicken and egg.
Yeah.
Sir?
What is the rule, or what happens when a law enforcement officer obtains from a judge the right, say, to look through a cell phone in which they suspect this fellow of sending secrets to Russia?
Okay.
Okay. And as they go through the cell phone, they find, oh my goodness, evidence this guy stole a Buick down in Texas, having nothing to do with what they were originally looking for.
That stuff is seizable under the plain view doctrine.
It's no different than a DNA swab. And whatever, you may be looking for one thing, but you find out this is the guy who's wanted down in Louisiana.
You got it.
So it's wide open once they go.
Yes, which is why it's so, I'll give you my own opinion, absurd that Chief Judge Kaczynski could suggest as an example that a judge suggest that the police waive their right to exercise a legal doctrine that is a constitutionally based exception to the Fourth Amendment. It's brazen to suggest, I think, that a judge can do that. But you're right. That's what plain view allows. If plain view isn't there, then what the court is, then what would have to happen is they would say, oh, we just saw this evidence that he stole a Buick. Okay, stop. Go back to the judge, get another warrant with stating the probable cause to believe that this person stole the Buick. But what's the probable cause to believe it? At that point, it's just, whoops, came upon this evidence by accident. Some judges won't let that just be the evidence. Some judges will say, don't come to me until you've got more. Go out and do some other investigation to corroborate the whoops. Then I'll hear you. That's a problem for law enforcement. Law enforcement needs to act on information that it has quickly, especially if the judge doesn't grant the search warrant for the stuff that doesn't perhaps grant a very general warrant for the first stuff and the person ends up getting off or something like that. Law enforcement wants as much and as many cases as they can have to hold on to somebody. So it's very important practically for law enforcement to have that available to them.
So do you think that essentially the country was misjudged the court decision in Wiley? That seemed to be, to most of us, a win for privacy and individual rights.
I couldn't agree more. I'm happy.
And we've been fooled. Is that what you're saying?
Nope. You haven't been fooled. That's the Fourth Amendment. I believe that's what the Fourth Amendment is supposed to be.
Right. And that's what the court said. You're just critical that they didn't go into the particularity of how it should be carried out.
Well, I'm not criticizing them. They're not supposed to give the judges the instructions. But I'm saying that those of us in the trenches have a much more practical we ask the practical questions that go along with that great theoretical concept. And that is, okay, we want to protect people's Fourth Amendment rights. We want to do what the Supreme Court tells us. We want to make sure that we balance the rights and the desires and the protocol of law enforcement with the rights of the defendant. We want to make sure that we give everyone that level playing field. So Riley's a fabulous decision that confirms the extent of a privacy right, but complicates the actual warrant process to obtain the information that Riley talks about.
Right.
It's a great decision. I mean, when I tell you I heard crickets, that was because I'm Woody Allen in that sense. But I did, like, the next day I got over myself and I did a little jig. And I'm not a judge anymore, so who cares? Oh no, my husband is raising his hand. He's not a plant, but it's his birthday, so I'm going to call on him. It's his birthday today. Happy birthday. Honey. All right, here's your birthday question. Ask it.
Isn't one of the big problems the fact that plain view is very different when you're comparing walking into a house or walking into an office than when you're flipping a cell phone on?
Absolutely.
And so what is reasonable when you're flipping a cell phone on?
He's not bad for a doctor, huh?
And that's why it's so hard.
Agreed. Gentlemen, in the red coat? Wait. Can you speak into the microphone, please?
Okay. You talked about testing reasonableness after the search.
Correct.
What are the penalties for that rummaging?
Sometimes it's complete suppression of the evidence, meaning the government is not allowed to use that evidence that it wrongfully obtained.
Even relevant information to the purpose of the original
Yes,
search? Okay.
yes, that's the risk law enforcement takes when they do it wrong, which is why most prosecutors with whom I have worked have really cared very much about law enforcement doing their job right. And they train law enforcement often. They have meetings with law enforcement to say, look, here's the right way to do it. Here's the legal way to do it. Please don't get it illegally. That doesn't help me. We lose the whole case, perhaps. Do it right. The problem, though, and I'll tell you, based on my own experience, I sat as a district court judge in the North Country of New Hampshire. Many of the police officers in the North Country are part-time. It's not even really their real job. They haven't been to the police academy for the full academy training. They have the bare certification. Those police officers are really not they only know what they study when it comes to computer stuff. No one's helping them out. Do you think when those officers come to me with a search warrant application that those search warrant applications are uniformly great? They're actually uniformly mediocre. And it's not the officer's fault, except the officer has usually not received the proper training and hasn't had the experience. They deal with these things so infrequently that they're out of practice. They do them so infrequently. I mean, it's one thing if you're a DC cop, drugs and guns, drugs and guns, drugs and guns all the time. It's another thing if you're the part-time police officer in Milan, New Hampshire. So that's the consequence. Doesn't have to be suppression. Sometimes it can be limitations, but most of the time it's suppression. You get it the wrong way, you can't use it. Evelyn. Okay, last question. Sorry, Max. Max always stumps me in class. I'm so happy we ran out of time before Max's question. Max answers me questions I can't answer. So but Evelyn does too. All right, go.
How does the concept of the unenumerated right to privacy come into play with concerns like this, particularly with the Fourth Amendment, but especially with digital information?
Well, that unenumerated privacy right that you're talking about is really the product of the substantive due process analysis. It's a substantive due process, Fifth Amendment, 14th Amendment argument. This is a Fourth Amendment situation. I wish I knew how to get back to the beginning without doing this. But if you look, you'll see in the Fourth Amendment, the language directly speaks to privacy. It directly speaks to a personal, to this sort of zone of privacy. There we go. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches. Not all searches, but secure. That's language that says privacy. So I don't think the unenumerated privacy right really has anything to do with it unless you're engaging in some sort of substantive due process analysis along with your Fourth Amendment analysis. Could it happen? Sure. All right, that's it, Joanne. Thank you very much. I really appreciate your time.